All right, going to call the meeting to order. I want to welcome everybody for returning to our meeting. Just want to clarify, this is not a public hearing. This is a continuation of our meeting from Tuesday night that we held on March the 19th. So it would be the same thing if we would have took a 5-minute break in that meeting. This is just a continuation of that meeting. As many of you may recall, when we closed that meeting, we went into closed session to consult with our attorney. And so now we are going to hear I'm going to call our attorney to the podium, or he can stand right there if he feels like, to give us some advice on this moratorium.
Yes, ma'am. Thank you very much. When last we spoke, I had some questions about this moratorium that you had voted on to move forward, and started doing some more research, and this weekend spent this week's research. I just want to make sure you know that it's my legal opinion, after looking at all the facts, and again, after relying on the seminal case in this of NRA campsites, unlimited, and based on a meeting or 2 meetings with the people from the School of Government, I'm going to be very open with you. Moving forward, a moratorium is not going to stop this flea market eventually, in my legal opinion. We don't have zoning. Zoning gives you the authority to stop or to regulate where a business goes within this realm. Now, that does not mean that they are not required to have building permits, to make code and things of that nature. But to enact a moratorium, you would have to find in a public hearing, it would have to be a clear statement of the problems or conditions necessitating a moratorium. You know, what courses of action other than a moratorium were considered by the city or county, and why those alternatives were not deemed adequate. Well, the first one right there is, even if you get to the moratorium and have the public hearing, I don't believe there's anything in there that could be permanently set forth to stop this flea market from coming. Now, as far as all flea markets, I don't believe you meet the criteria for that either, which is what a purpose of a moratorium is. It's for a type of business or to stop something. There's a great article I provided to y'all by David Owens. David Owens has retired now from the School of Government. He's the planning guru of North Carolina. He's the one that decides in North Carolina, or he doesn't decide, he's the one that has, for the last I don't know how many decades, compiled all the research, and every time there's a moratorium or a planning issue or a zoning issue, he was the go-to person. He's written numerous books on the subject. He would be considered a legal treatise under many court rules and things of that nature. And one of the things in here it says you have the authority to adopt these processes, or to adopt these process to do a moratorium, but it needs to be done with certain particular purposes. And one of the purposes is to enact or to act like zoning when you don't have zoning, just to stop something from coming there. If we had something like a monumental imminent threat to public health or safety, you could enact a moratorium, but then even after that, you have to articulate exactly what you're trying to stop and what you're trying to prevent. And then that subject, or the business that is subject to the moratorium, would be allowed to react to that and to correct that situation. It would not be something that would be permanent. Zoning is permanent. For at least 15 years, and I may have bothered y'all with this so many times, for at least 15 years, the citizens have stopped zoning from coming. Many of the citizens have voiced their opinions against zoning in Anson County. Like I said, I may have said this in a meeting, I know I've said it many other times. We had a meeting, we had a lady by the name of Ms. Baptiste. She had a plan implemented. That was probably 12 to 15 years ago, I think. She had a plan implemented. It was here. Then Commissioner Mr. Bobby Sykes said that citizens had contacted him I believe Dr. Sims had agreed with that. They asked, they said, well, does that mean that they voiced concern that zoning gives the government the right to tell people what to do with their land? And I responded, yes, it does. But he said, so if we don't have zoning, the government can't tell you what to do with your land. I said, yeah, but you also can't tell your neighbor what they can do with their land. And that's the whole purpose of it. So when you move, zoning is designed to where when you move to an area, you can look at that zoned area and decide what's going to come around you, what's going to be around you. If here in Anson County, in rural Anson County, we don't have zoning. Therefore, when you do move to a place, you're taking the chance until zoning is enacted, what could and could not come to the property beside you. I'll be very frank with you. Nothing against the flea market. I would not want a business like that to take the place of the nice, beautiful fields that are across the street from my house. However, because it's not zoned, there was nothing legally that I know of that I could do to stop it if it was in my neighborhood either. Also, my legal opinion, this would be for the purpose of stopping a business from coming to a place that it has a legal right to come to. Now, there's other forms that people could do that if they disagree with me, they could hire a lawyer and try and form an injunction or something like that to stop it from coming on their, if that's what they believe. I just don't see a legal ramification. I don't see the legal right to enact this for the purpose of permanently stopping something. In other words, if you do this, we're going to have a hearing. That hearing is going to have to be, and I did not explain this that night to you, Commissioner Gatewood. I wish I was a little more prepared for that on things. I'm going to take my chance to do. I'm going to take this chance to do it now. We have to find 4 things. I've already read out 1. It would be a clear statement of the problems and conditions necessitating a moratorium, and what courses of action other than a moratorium were considered. A clear statement of the development approvals subject to the moratorium and how a moratorium on those approvals will address the problems that led to the imposition. In this scenario, it would be flea markets. The moratorium would be on flea markets. And then we would have to say that the moratorium enacted, we have to go back to number 1 and say how that would remedy this situation. What need or what danger are we curtailing by doing this? Number 3, the third thing that would have to be stated in the moratorium would be an express date for termination of the moratorium and a statement setting forth why that duration is reasonably necessary to address the problems that lead to its imposition. Imposition. In other words, we have to say why we're doing it. Then we have to show what we did instead of a moratorium, and then also a clear statement of the approvals subject to that would remedy the situation. And then number 3, an express date for the termination of that. In other words, there's going to be an end date to this. And at the end of that moratorium, flea markets would be allowed to resume under those conditions that were addressed. Number 4, a clear statement of the actions and the schedule for those actions proposed to be taken by the city or county, here would be the county, during the moratorium to address the problems in its lead positions that led to the imposition. You have to note what the problem is. You have to find the remedy. You have to show when you're going to have it done by, what steps need to be taken to do this by, and then a clear statement of the actions and a schedule on this. So this may kick the can down the road. A moratorium may kick the can down the road, but it's not going to resolve the local citizens issue in my view. Also this, if you look on the statute, it clearly states letter F, if a moratorium is challenged by the people against which it is formed, then it would be the responsibility of the county. They have the burden to prove all these elements and what they did. And if not, they'd be subject to the losing of the lawsuit and any of the ramifications that come with that lawsuit. To be quite frank with you, what damage did a wrong moratorium, if it is deemed to be wrong, what an inaccurate moratorium would be deemed to be. It would also be given, expedited status with the Superior Court of the county to enact on that too. So, I want to remind you of something else. This is a very common ailment with people where change comes to a community where they're used to being, especially in rural areas. It's a very common element that people enjoy a nice, peaceful neighborhood, and then something comes in to change it. If there's no zoning, that's what happens. I personally, I live in Peachland, love the area, used to enjoy with my father and then with my kids going to Carly Jackson's store. There's no zoning there. It was a beautiful store, a little quaint little store. A lot of people remember it. Well, now it's a junkyard, and there's nothing you can do about it because we don't have zoning. I've tried calling DOT about it. All they do is push the cars back. All that does is make the junkyard bigger. And I'm probably going to get phone calls about calling that place a junkyard. That's what it is, and I'll stand behind that. That's me as Scott Forbes talking, not the county attorney. I empathize with people that do not want things in their yard that are in their neighborhood. However, without zoning, I don't see us going forward. In this case right here, this is the seminal case in North Carolina, and it is NRA campsites. Happened in Norwood, North Carolina. Around 1971, a man bought 155 acres. They didn't have zoning in Norwood at that time. Around 1972, 73, sometime in there, Stanley County decided they wanted to implement zoning. They started a zoning panel. The person that had the campground had already purchased the land, had already stated he was going to build a campground, and he moved forward. He even said that he was doing it so quickly because he was trying to beat the zoning. The state of the North Carolina Supreme Court still sided with him and said he was already vested. He had already bought the land. He had already bought the land, had already started the construction on the property, developing the property, had already spent money before they implemented zoning. Let me also tell you about what I understand the simple facts to be in this case after careful research from everyone. As I understand it, Sweet Union Flea Market in Monroe closed down. The owners of that place started looking for other areas to operate a flea market. It's my understanding they went to a place called Midland. They found a piece of land they liked there. They checked with the area there. There was no zoning allowed. There was zoning there that did not allow flea markets. Then they came to Anson County. They looked at a piece of land, saw the piece of land, decided to look for permits. They went to go see Mr. Keith Gaskins. He did his job. He sent them to Larry Newton, our planning office. Mr. Larry Newton did his job. He advised them there was no zoning here. He did give them some other directions. They started following those directions. They acted upon that, as I understand it. They acted upon that, bought that land, and started doing all the legal things that they could do because it was actually it's deemed an agricultural site because it had old either turkey or chicken houses on it. They started doing some things. Work permit was a stop work order was placed to stop some of the work that was not permitted. It's my understanding, loosely, they need permits for plumbing, electrical, and the roofing, some of the carpentry stuff. It's legal for them to do all the grading and all the upgrades and the pouring the cement and all that stuff. It's legal for them to do that. They have spent money in anticipation of this not being zoned and them having them list. That is, as I interpret it, the definition of vested. Once they have vested rights on this, again, it appears that in my opinion, I believe a judge would find that they have acted in good faith. That any zoning or moratorium that would be implemented now would be overturned or would not be effective against them either way. That is, and it would subject maybe the commissioners individually to a lawsuit, but definitely the county to a lawsuit. That's my opinion. And I just wanted to, my advice would be to retract a moratorium or to not go forward with a moratorium at this time. Again, anyone who disagrees with that can certainly try to file an injunction to get it stopped. There's nothing with that. I'm giving my advice to my clients. That's what I'm doing. Do you have any questions, please?
I'll open it up to commissioners first.
Yes, sir.
Mr. Chairman, I have a question and then I have a comment after I get the answer, and that is, you mentioned that our planning officer and permitting officer did their jobs. Did anyone from those offices go up to the site to see if it was compatible with rural country life as we know it in Burnsville and Peachland?
To my knowledge, they did not, but that is not one of the criteria for determining. Because there's no zoning, they answered the question not being zoning. Now, is it not compatible with a quiet neighborhood that exists there now? You could make that argument that it's not. It's definitely not the same as the nice homes that live in that, or that reside in that area. However, it's not zoned. Therefore, just like Carl E. Jackson's store, people came in and they have decided to implement a flea market on that thing. That is my legal opinion, that they had the right to do it. I don't know that they traveled to the site. I know that Mr. Gaskins, or Keith Gaskins, has gone to the site to issue stop work orders and to inspect the site, and is waiting on some architectural drawings and things of that nature. I hope I'm answering your question. I don't know that they actually visited the site for that purpose, but I believe he did pull up the zoning map to make sure there was no zoning in that area. But that's something you'd have to ask him. I'd be surprised if he didn't. I didn't get any. I have not found that he gave him any incorrect information about it not being zoned.
Well, my question is,
Yes, sir.
did anyone from the permitting or the planning office visit the site before we started implementing and signing documents?
I don't know that for sure.
Does anyone know?
I don't know.
I heard about the flea market through the grapevine, and the information I received is that it was well underway. Reconstruction had already started, and I'm thinking to myself, something this big and out of the ordinary, where there's going to be large crowds, lots of traffic every Friday, Saturday and Sunday, or Saturday and Sunday, and you have a church, Hopewell Methodist Church, within a half-mile of this site, and you've got neighbors around this site, and the roads are narrow and crooked and curvy. It just seems totally out of order, and I would have thought that someone from the county would have gone up, looked at the site, and said, hey, this is inappropriate, and then come back to the Board of Commissioners and made that known. So I'm not sure that we did our job to the best we could have, Mr. Attorney, and I understand where you're coming from.
Yes, sir.
But that's just my humble opinion.
Yes, sir. Mr.
I'd like to add what Commissioner Gatewood says. Something I've thought about since we've been talking about this is, going forward, is there some process, and this is directed more to Mr. Sossaman than anyone else, is there something that could be put in place until we have the zoning ordinance adopted, that any of the county departments involved in a business starting up, once they get like a request for a permit, or they have to do whatever it is, just as soon as they get that, they let you know. And if it appears in your opinion that it's something, and maybe even if you don't want to make that call, that it comes to the commissioners before whoever the business owner is given the approval to move forward. That'd be something, because like I said at our last meeting, since I've been on this board, so many of these types of things have happened, I've lost track of them, because like I said, we don't find out until it comes to us from the community that's negatively impacted by something. If there's something great that everybody wants, we never hear about it until it's up and running. But these types of situations, we need to know ahead of time, as Commissioner Gatewood has said. And I don't know how much trouble it will be, but I'd like for Mr. Sossaman to get with the department heads involved in the process and see what could be put in place before any kind of a permit or go-ahead is given is that you're made aware of it, so the board can be made aware of it. And it can be addressed up front rather than after the fact.
And I think part of that, Commissioner, and going back to what Mr. Gatewood said, is right now, since there is very limited zoning in Anson County, that creates a problem from a permitting perspective. And from Mr. Gaskin's perspective, if someone, and it's my understanding that plan specifications are being developed. I haven't seen them yet, and when I chatted with Mr. Gaskins and our fire marshal last Friday, they had not received any plans yet. But that doesn't mean they're not underway. And as the attorney just said, they're going to have to submit those in order to get some type of certificate of occupancy from our building inspector. But you did bring up at a previous meeting, I think it was the last one, that what we need, since you're now considering seriously a zoning ordinance for the entire county, is to have a bona fide planning director who would oversee zoning and also inspections. Then that would probably resolve this issue in terms of things getting to you. Because now, since there's no zoning, it probably was off the cuff, but I can see where it happened. I'm not saying it was right.
Right.
But somebody said, "Can I put a flea market on this property with no zoning?" And the answer was obviously yes. Now, had zoning been implemented, and then over the last year and a half or two, since you had that 2020 draft, you could have made amendments to it, and then since that property would have been zoned rural up there or agricultural, it would have prohibited such. But unfortunately, it's like closing the barn door after the horses are gone.
Yeah, I understand, I think all this, and I'm not sure if this went before the planning board, but that's an option too, is that anything that comes to the planning board before they give their approval, is that the commissioners are made aware of it. It's not necessarily, so we can say we know about it up front and say yay or nay that this should proceed. That's what I'm just trying to get something in place for now, so that we hear about stuff up front rather than after the fact until zoning's in place, which I'm hoping the zoning will be in place here shortly. But
I hope so too, because I think that will solve a lot of issues, and it would do something that you just mentioned. There are things called special exceptions in most every zoning ordinance, and from what my reading of our zoning ordinance going to be proposed to you, there are special exceptions. Those would not be approved by staff. They would have to go to the planning board for approval. And then there's others that, if not approved there, then it would come to this board as a commission for final approval.
Mr. Chairman,
Yes.
as of yesterday, I visited the site 3 times now. A lot of rumors floating around about what's going on up there. The first time I visited the site was about a month ago, and I was appalled. I said, how did this ever get through the screening process, the initial screening process? If I'm appalled at the size, the location, the inappropriateness of the location, then I would expect our planning officer and our permitting officer to have a similar response. To make sure that I wasn't overreacting, I took a neighbor up there with me the second day, and she was appalled at it. How in the world did this happen in this area? Given the narrowness of Faulkner Road, given the close proximity to the church, given the increased traffic and noise and who knows whatever. But my point is, I don't think we've done our job appropriately, and I think it behooves us to go forward with the public hearing.
Okay, thank you. Any other?
I had a few questions I wrote down. As of now, there will be no waiver of existing regulations just because there are no zoning, is that correct? There would be no waiver of existing regulations that everyone else has to comply with just because there's no zoning.
Absolutely not. No,
The building permit office will still require compliance with their code enforcement, is that correct?
that is correct.
The emergency management services will still determine the safety protections needed to operate the business, is that correct?
That is correct.
The health department will still determine the requirements pertaining to the bathroom facilities that are going to be needed if this operation were to take place, is that correct?
To my understanding, if I may, to my understanding, a moratorium would just stop construction on this, or could stop construction on it and stop the opening of the building. For them to meet the criteria, with or without a moratorium, if you don't have a moratorium, they still have to comply with all the things that the fire marshal, EMS, any type of permits, everything has to be complied with upon this. We just had the county, as y'all are aware, the county does inspections for the town as well.
Mm-hmm.
They just made a new restaurant, or a proposed new restaurant, spend I think $5,000 to $6,000 on doors to open properly. They had everything ready. That was the last thing on it. They still have to comply with these safety measures. They still have to. The only issue here is there's not a zone. There's no zoning to stop it from coming. But by no means does that mean that they do not have to follow all the rules, regulations, present a nice, safe, legitimate business, and all the rules that go along with that.
And
this is just for the zoning part.
And that's
Yes,
what I'm
sir.
trying to clarify. And the last note I had was about DOT. If they have certain regulations that they need to comply with on the width of the road, the apron to the exit or ingress or egress, parking. So the DOT will still create the criteria that they would have to meet in order to comply with them. And what I was going to mention, the four departments that I just mentioned all have statutory authority to enforce those regulations. Is that correct?
That's the reason for their existence, yes.
Okay, I just wanted to make sure that everybody knows that there's nothing that's going to be allowed here because there's no zoning that wouldn't be or would be whether there was zoning or not, right?
That is correct. To further this, any problems that arise, such as traffic or anything like that, any concerns that come up, even after they're open, if it's a threat to safety or anything, they would still have to, every business still has to provide a safe, proper business and a proper. It can't be a nuisance to the area or to the entire county. It just can't. They have certain things that they have to comply with. That's every business. So to answer your question, if there's a traffic problem out there, it needs to be handled. And I don't know to what degree or anything like that. And that's just something that came up with because people are talking about the narrow 17 foot wide road out there. But there's codes going along with what you're saying. I believe has to be a 20-foot wide driveway all the way around all the facilities and things of that nature. That is something to
Because some of the concern was because there's no zoning means there's no rules, and I'm just trying to clarify that that all of these regulatory authorities that I just mentioned and you confirmed will still be involved in this and still be in charge of ensuring that all of the compliances are met.
That is correct.
Okay,
The
thank you.
zoning just determines what can go there. Building permits and rules and things of that nature determine if they've met the criteria to be allowed to go there.
Yes, sir. Thank you.
Yes.
I just want to clarify, when we talk about traffic on Faulkner Road, the county has no authority over the traffic on Faulkner Road. Is that correct?
They can't expand the road.
We don't pave
if
the
there
roads,
was a-
we don't widen the roads, we don't maintain the roads. North Carolina DOT does that, correct?
That is their road.
North Carolina DOT does the traffic studies on the road to determine if, in other words, I don't have the authority to say there's too much traffic on Green Street right here, right?
That is correct. To your question though, your concern, it would be my position, and I think the county's position, that should there be an issue with traffic to where there was some type of safety issue, a wreck, a bump up, stopping the traffic, anything like that, I believe local law enforcement could enforce those rules there, if that's what you're asking. But widening the road, discussing the amount, limiting the ability to have a business there because of the flow of traffic, I don't see
Okay.
where that would be the county's perspective.
Mr. Chairman, I think you raised an excellent point regarding DOT and whether or not they have completed a traffic study. Have they completed a traffic study?
I'm not aware of that. I'm not aware. I'm just not aware.
The last understanding I have from Mr. Newton, we did reach out to DOT regarding a traffic study, and I think they are working on trying to, I don't know their process, but they are trying to perform a study on that location.
And I've called DOT myself, not to assume any authority over them, but to make sure they're aware of what's going on, and they have complied with the fact that they're moving forward with study and aware of the fact, because speed limits and road widths and things like that, although we have no authority over them, we can certainly be concerned about them.
Well, normally I'm sorry, Mr. Chairman, may I?
Yes.
Normally when there's an issue regarding DOT, they will come to the board and make their presentation. I would certainly encourage them to come to the Board of Commissioners and share with us their findings regarding this flea market on narrow Faulkner Road, as well as the roads leading to it. That's information that we need.
Yes, sir. That's a fair assessment. And like I said, the last email I got, they were in the process of whatever their process is of doing a study. And I can't update you no more than that. But
I mean, the county manager could make that request. Go ahead and put it in now, so that when they've got the information.
And the chairman's right, Commissioner Woodburn. They have confirmed that they have been contacted, and they're now looking into it, researching it, if you will, and what kind of traffic study. But I can send them another email and encourage them to expedite the process.
I'm talking about when they get the information. They
yes.
report to you, so it can be brought. I'll come. You tell them they need to come and report to the Board of Commissioners.
Right.
okay. Mr. Attorney, at this time, I want to ask, you referenced the 4 requirements to hold a public hearing for a moratorium that Mr. Owens wrote.
If you have a moratorium, you can hold the public hearing for a moratorium, but these would be the required statements. I think I handed them out to you last time.
Yes, I've got them right here.
Sir.
Yes.
Those would be the 4 required statements that I spoke about earlier. In other words, you can have the public hearing, and at the end of the public hearing, it says, and I'll read the first one. It says, the moratorium must be adopted as an ordinance by the county. The ordinance establishing it must expressly include the following 4 items. So any moratorium that you do, you have to make findings of fact to support these 4 before you can implement a moratorium.
My question is, in your opinion, in your legal opinion, have we met the 4 requirements that if we hold a public hearing, we'll hold up to a moratorium?
I want to make sure I answer this properly, because this has been the one thing. You can hold a moratorium.
Mm-hmm.
It's my opinion from the facts that I have. The concerns that have been expressed will not satisfy these 4 criteria. That's my opinion.
Okay.
I'm not trying to be a lawyer and double talk you either. I really am not. That's as accurate as I can give you. I have not heard, in my legal opinion, what has been stated, the concerns. I don't think you're going to be able to meet these 4 criteria. And also your ultimate goal, at the end, you're going to have to set a date of when it can be done.
Okay.
Even if you do meet these criteria.
If you meet it, yes.
Still come on.
Okay.
That's my opinion.
Okay. I got one other question. Can you, and you briefly explained on it, you touched on vested right.
Yes.
Can you explain in this case what would vested right detail or?
They bought the land based on no zoning, and from as I understand, the fact is they bought the land, they started working on it with the assumption that there's no zoning and the assurances that no zoning would be implemented to block them. In other words, when the land was purchased, they had the legal right to do what they said they were going to do with the land, and they've done it. Or as far as I can tell, they've proceeded through that. I have not found any evidence to the contrary on that. The grading of the land, they spent money on it. They've changed the land just like they did in Ray campsites. They spent their money. They foretold that it is going to be a flea market. They started doing the buildings. Some of that work has been stopped, but they're going through the process to resume it. They have worked on the land. They've expanded. They have hauled in dirt, from what I understand. That's what I've gathered. It has not been under oath, but everything in here that I've heard from both sides that they've expended the money. I've been to the site. They've done a lot of work on it. It's amazing how much work they've done. They have hauled in rock. It looks like they've spread rock. They have poured cement. It looks like they've done some work, and they've anticipated. They've also hired an architect, as I understand. And though that would be vesting their rights to do something. In other words, if you buy a piece of property that's zoned agricultural and a flea market is, or any other business is not allowed to be there, and you buy that saying, hey, we're going to see if we can't get the planning board to change it, and then the planning board doesn't change it, then you're just out.
You don't have no vested
If
right.
you buy something, if you buy a piece of land, start working it based on the legal presumptions and the legal rights that you had at that time for them to change it without it being a threat to safety and things of that nature. And this is a broad general statement. They would still have the rights vested in that.
Mr. Attorney,
Yes, sir.
I'm sorry, Mr. Chairman.
Yes, sir.
Thank you for recognizing me. Okay, I get excited sometimes. What is the purpose of a public hearing?
Public hearing is to ferret out information, to make sure that, and to gather information for you to make an educated decision on something, or to reveal more information, and for you to have a public forum for that.
Absolutely. As I stated before, I think it behooves the board to proceed with the public hearing. Lots of rumors floating around. At our last meeting, there was a rumor that the road was being widened. Faulkner Road is not being widened, okay? There are some ugly rumors that I don't even want to repeat out of courtesy. But if there are issues out there that we haven't heard yet, that's the reason why we have a public hearing. And at the appropriate time, I'm prepared to make a motion that we proceed with the public hearing.
Okay. Any other, I mean, I guess we got a motion on the floor, so any other discussion? Okay, hearing no other discussion, we have a motion to, and
Are you through with me? I'm ready. You tell me, whatever you need.
do we have to have a motion? In other words, I guess you need to clarify this.
I'll be glad to, in anticipation of this. You can have a vote on that if you want to. But right now, if you don't vote or take any action,
Wait.
we're scheduling the public hearing.
Okay.
You're scheduling the public hearing. If that was your question.
Yeah, that's where I was going. I didn't know if we had to vote again to hold a public hearing that we've already voted to have.
Quite the opposite.
Okay.
I just wanted to make sure, Mr. Chairman.
Thank you.
All right, thank you.
So,
Are we still, Mr. Chairman?
yes.
In moving forward with the public hearing, would that simultaneously, if we were to vote on that now, be moving forward with the moratorium?
No. Oh, what? Let me anticipate your question if I understood it correctly. If you vote not to have the public hearing, you're not going to have a public. You have to have at this point with the evidence that's been presented, in my opinion, you have to have a public hearing before you can implement a moratorium. I don't see anything of imminent harm or danger coming from the flea market at this time that has to be corrected by stopping it right now. I'm not saying it's not going to change the neighborhood and all that stuff. I'm just saying imminent harm to the neighborhood, to the public or anything like that.
Well, I guess in reverse,
If that's what you're asking.
I guess the way I meant is, because we've not had a public hearing, we don't officially have a moratorium in place at this time.
That is correct. At first, I thought that I heard, as I went back and listened to everything, and I think I even advised some people that we have a moratorium because I was under the impression it was for the safety and imminent threat, but I did not hear anything that would lean to it being an imminent threat to the harm and public safety of the people. So, you don't have a moratorium. That was an interpretation that I had made that upon further review I didn't have the correct information at that time. Upon further study, you do not have a moratorium at this time. And that is what I did. I wrote a letter to the flea market president, Mr. Diaz, and he acknowledged it, and he called me, and he acknowledged getting it, and I told him at that time, there is going to be a public hearing on that time. So, but that is subject to y'all withdrawing that at any time. May I ask, is Mr. Diaz here? Okay, great, thank you. He said, I just want to make sure, so I would not have to contact him personally.
Okay.
Well, I guess my question would be, if they have a flea market and then there's problems, can we not go back and issue at that point to stop, to do immediate to stop it?
If you have
If
some
they-
type of public safety, if you have,
Yeah.
like with any business, if you have problems like that, you can shut them down under certain circumstances. Also this, anyone who disagrees with my opinion is free to, they can hire an attorney to try and get an injunction done. I'm not advising someone to do that. I'm just saying, I want to make sure they know that it does not stop here, that someone can act privately. You can act privately. I don't know what their success rate would be, but I would just say that is a legal option.
So I'm going to ask the question, if we don't have a moratorium in place currently, what's the stop work order issued for?
Because they were not in compliance with some, they were not in compliance with some of the permitting because they
permits.
did not have the drawings put in.
So if they get their permits or their drawings put in place within the next 3 weeks before this moratorium's put in place, what prevents them from opening?
If you implement the moratorium,
There is no moratorium.
I'm saying if
There
you
won't be
were
one for
to
3 weeks.
implement one,
There won't be
you're
one
right,
for 3
that would
weeks.
not- That would not stop them from ordering. And it's not designed, a moratorium is not designed to do that. A moratorium is to prevent, some type of problem and to, the problems and conditions necessitating a moratorium is what it's for. And what would be our reasons for doing this? An improper one would be just to keep it a field and to
keep it out of that
doesn't work with the
location.
residential area. As sympathetic as I am to that cause, I love a pasture, I love the country. Without zoning, we're gonna have this come up again.
I have a question. So even
Yes,
after
sir.
zoning is in place,
Yes,
if we
sir.
start having problems up in the flea market, we can reissue.
Oh,
and-
yes, sir, you can,
And then we can stop it.
if there's some type of problem with the flea market, yes, sir, or any type of problem, as with any business. They would be subject to any laws, any business, not just them, any business like that is that, so.
Mr. Chairman, we have a motion on the floor to proceed with the public hearing.
I guess I got one more comment. Mr. Chairman?
Yeah, go ahead.
Based on your recommendation, I'm against a moratorium, but I'm not necessarily against a public hearing. That's what I'm trying to clarify. And the public hearing could ultimately lead to a moratorium, but my concern is it doesn't sound like, based on your opinion, that we have the criteria to meet a moratorium, but that doesn't mean that there can't be a public hearing.
That's correct. You can always have a public hearing. If that's your question, you can. I was forecasting, and as Commissioner Gatewood has pointed out, there may be some things revealed, but at the end, even with a moratorium, I don't see you ending the flea market coming to this area. Even if you have a public hearing, even if you implement it, I don't see that being the end of this. I don't believe that would. I don't think it's going to cause the flea market not to be able to come.
Would a negative report from DOT, could it cause this
They
flea
stop
market?
it, that's on them.
That's on them.
That's on them. If
Absolutely.
they stop it, it's on them. Yes,
Sure.
sir. That would not be us. And I'm
All right,
not trying
thank
to
you.
kick the can or shift the buck or anything like that, but from my understanding, DOT can stop anything.
To my understanding, even if we said, yes, go ahead, DOT still has the authority to stop it, correct?
That is correct.
That's-
We can't override DOT.
And we'll
They
run
have to
into,
satisfy both entities.
we'll run into that when the bypass comes, because people are going to expect us to stand up against that, and we'll have no authority. So it's a similar thing.
That's the state of North Carolina mandating that, and we don't exist without them.
Okay, any other discussions?
No discussion. As I understand it, there's not a need for a motion to have a public hearing, because that's going to happen anyway, right? Hasn't it already been put in place? It has a date and time?
There is a public hearing that is tentatively scheduled for April, so that's why I was trying to clarify. I don't know that we need to vote to have another one. At this time, the only action that the board I could see would take was if there was someone entertaining the motion to lift the moratorium and not proceed forward with a public hearing.
But Mr. Chairman, since we don't have a moratorium in place, we don't have to lift something that doesn't exist, right?
Well, yeah, I guess the only action the board could take is to
Implement.
to not proceed forward with having a public hearing. That would be the only other action the board would take at this time, I think. Correct, Mr. Forbes?
That is correct.
Okay. So, is it the board's pleasure to continue with a public hearing or take other action?
I say let the public hearing stand.
Okay. So,
Do we need to vote on this, Mr. Chairman?
up to Mr. Forbes, according to him, we don't need to vote because it's already in place.
If you don't vote not to, it's our intention to advertise it tomorrow.
All right, very good. Thank you.
And the date is?
The tentative date, April
16th, I believe.
That's correct.
okay, April 16th, which will be our second meeting, county commissioner meeting in April. So it'll be held here in this room.
I want to be clear. It's in my opinion that there's not a moratorium right now. There could be one implemented on April 16th.
Okay.
Okay? But there's not a moratorium on any flea market. So other flea markets are coming on.
Any other flea market can open in any part of the county.
That's what a moratorium is about. All flea markets in Anson County, as I understand moratorium laws.
Okay.
Just one thing, it's my understanding that you would have to prepare an ordinance for the board to adopt after they conclude the public hearing on April 16. And then that would actually implement, that ordinance would actually meet those 4 criteria, or at least 3 of them, to start the moratorium.
It will have to state that plainly in the ordinance, and then we'll also have to have a date by which the moratorium is over.
Right, and the board
Okay.
could actually set the stop date at the meeting on the 16th.
If it meets that criteria, you could, okay,
Right.
the stop date for
Right.
the moratorium.
For the moratorium.
Gotcha, yes,
Because the
that is
start-
correct.
Because the start date, sir, I'm trying to be clear, so the start date, if the ordinance meets the criteria on the 16th day of April, the start date would probably be immediately, which would be the
Will of the
16th,
board.
if it's up to this
Yes.
board. And
If
then
it
they
goes
then
to
would have to,
moratorium.
they would have to insert a stop date once those criteria that necessitate, that necessitates the moratorium, those criteria would have to be addressed in there.
Yes.
And then on the stop date would only be effectuated if those criteria have been resolved.
That is correct.
Okay.
Also, it would not stop any vested, if a flea market, in this scenario, if a flea market has vested rights, it would not do anything to take away those vested rights. So if they would still have it can't erase the vested rights, it can't be retroactive.
Okay.
So just letting you know. Okay.
Okay. Any other discussion for Mr. Forbes or regarding this moratorium?
Well, I'd like to compliment Mr. Forbes for his excellent research, very
Thank you,
in-depth
sir.
research since our last meeting on Tuesday. He's done an excellent job. I'd also
sir.
like to recognize the supporters of the flea market. Someone asked me the other day, what is your problem with flea markets? I have no problem with flea markets, none whatsoever. But I can envision a carnival taking place every Friday, Saturday, and Sunday, and at least Saturday and Sunday, in this 10-acre, 12-acre site on Faulkner Road. And I think, to your point, Mr. Mims, we may have to close it down once it's a nuisance every weekend.
That's right.
And that's what I envision. I'm not a fortune teller. I used to be one, so I'm out of practice. But I envision that we'll have nuisance reports every weekend on this flea market. And then this board will have to take further action.
Very well said, Mr. Goodwin.
Also, I want to compliment the citizens from Burnsville. I empathize with you. I've said it before publicly and privately. Anyone that'll listen, I would not want it in my backyard or anywhere near my neighborhood. You've got a beautiful area up there, and I just hate to see it disrupted, quite frankly. Beautiful people. Thank you. Thank you, Mr. Chairman.
Thank you. I just want to clarify, do I need Mr. Gatewood to rescind his motion if we're not going to take action on it?
It dies for
Or did it die?
Was it
Okay.
seconded?
No, it was not
Dies for lack
seconded.
of
So, okay. So, just clarify.
That's fine.
All right. Thank you. Okay. At this time, any other business we need to take care of today?
You think you need to call for that second? You never call for that second, and you can get it, but you never call for it.
We don't have to have the motion because it dies and it's going to continue either way. It was just reaffirming what we had already put in place. So, Okay. Any other business?
Mr. Chairman.
Yes, sir.
Mr. Woodman, we have a meeting tomorrow?
Oh, yes, the NCACC District 10 meeting is tomorrow at Lockhart Taylor Center. It starts at 12 noon. The attendance is not going to be as good as I was expecting from the surrounding counties, but I still like for all of us to be there. And the association has, I think, 4 people coming. So, and they'll be providing information and all. I think that'll be beneficial to all of the counties.
Okay.
So please be there.
I look forward to being there.
Thank you all.
Mr. Chairman.
Yes.
Chairman, is lunch included?
Yes, sir.
Excellent. I will be there.
Yes, sir.
One thing I'd like to clarify, because it was stated in one of the previous meetings that maybe we're not engaged in this process. I'm sure the attorney can tell you that I speak to him almost every day about this. I'm sure that if our EMS department was here, they could tell you I speak to them many times, several times a week. Our building permit office will tell you the same thing. We're engaged in this. We're staying on top of it. We're trying to learn everything we can, and we're trying to make the right decision. I go by that place. I was also understanding in one of the previous meetings that we've not been visiting the site. I go by there every single day. You know where I live. I go by there every day, and I look at that site, and I try to keep an eye on what's going on just from my own knowledge so I can learn from it. So I just want to make that known.
Thank you, Commissioner Bricken. Any other comments, concerns, business? Okay. Hearing none, I'll entertain a motion to adjourn.
To adjourn, Mr. Chairman.
Thank you. Second.
Second.
All right. All in favor, say aye.
Aye.